It's my pleasure to welcome you here this afternoon on behalf of CORE and on behalf of our event partners, the Business and Human Rights Resource Centre and the British Institute of International and Comparative Law. And a big welcome to our speakers, particularly people who have travelled from outside of the UK to be here. We're here this afternoon to talk about access to justice for victims of corporate abuse overseas, and often this is a fairly theoretical discussion, so I wanted to begin this afternoon by giving you a brief reminder of the presence in our daily lives of products produced by workers and farmers overseas. I'm using my phone to time this session. This phone that I carry around with me every day, like your phones, relies on minerals and metals mined in Congo and Indonesia and elsewhere. Most of our clothing is now produced outside of the EU. I looked at the label in this dress this morning. It tells me it was made in China. I was at this point going to hold up a banana, but I left it in my handbag. I'm going to eat it in the break. It was grown by farmers in the Dominican Republic. It is a fair trade banana, I should mention that. So you can see how heavily reliant we are personally on the labour and the land of people in developing countries, and the extent to which the profitability of European multinationals is founded on resources and labour overseas. And of course, the very significant expansion of transnational business over the last 30 years has brought some benefits to the developing world, but it has also gone hand in hand with, at times, a very high price. You'll all be familiar with examples of the impacts of corporate abuse, but to give an illustration of the scale of the problem, earlier this year the Business and Human Rights Resource Centre produced its latest regional briefings on Eastern and Francophone Africa. The former showed how a boom in inward investment in oil, gas and agribusiness had been accompanied by a 5-fold increase in allegations of corporate abuse, while in Francophone Africa, the past 2 years have seen a dramatic increase in concerns regarding the agriculture sector in the region, reflecting in part huge acquisitions of land for palm oil, sugar, biofuels and other crops, often without the consent of the communities involved. The UNGPs were designed essentially to try and deal with some of these issues, and as you'll know, the third pillar of the framework is access to remedy. This project that the conference is a part of is designed to look at how we can improve access to civil justice in the EU for victims of human rights abuses related to the activities of European multinationals in developing countries, and it builds on the work that CORE did with the European Coalition for Corporate Justice and the International Corporate Accountability Roundtable when we commissioned the third pillar report last year, which Robert will present in a moment. Ideally, victims of corporate abuse would be able to access justice in their own countries, but for many reasons with which we are familiar, corruption, low standards of legal protection, lack of enforcement, this remains very difficult and is frequently impossible. The key output of this project will be a list of recommendations for policymakers on actions required to improve access to justice, and I very much encourage you to contribute to the development of those recommendations by sharing thoughts and ideas during the discussions that will follow each of the panels this afternoon. So to conclude, there is a clear duty on states to protect human rights, and this includes a duty to provide effective remedies for violations of human rights. There is a responsibility on companies to respect all human rights, including respecting the right to remedy, and in this context, John Ruggie has affirmed that companies that obstruct judicial mechanisms act at variance with their responsibility to respect. Multinationals benefit from being headquartered in the UK. They benefit from listing on the London Stock Exchange, and they benefit from government support, such as access to export finance and trade missions. And so there is an onus on the UK government to demand that these companies operate to the highest standards and to ensure that they are held to account if they harm people. It is not sufficient to rely on company grievance mechanisms and voluntary approaches to deal with corporate abuse. Government must take action to facilitate access to judicial remedy, and failure to do so will lead to continuing impunity and ongoing harm. I will introduce the panel. Professor Robert McCorkdale is the Director of the British Institute of International and Comparative Law. Robert is also a Professor of International Law and Human Rights at the University of Nottingham and a barrister at Brick Court Chambers in London. Robert is one of the co-authors of the Third Pillar report, and he will take us through that report this afternoon. Seema Joshi is Head of Business and Human Rights at Amnesty International. Earlier this year, Amnesty published Injustice Incorporated, a book which focuses on 4 emblematic cases and exposes how corporate, political and financial power, entwined with legal obstacles, allow companies to evade accountability. And Richard Meeran. Richard is a partner at Lee Day. Richard has pioneered claims against UK-based multinationals and is now acting for more than 4,000 South African gold miners in silicosis litigation against Anglo-American South Africa, and is also currently representing a group of Tanzanian villagers in a claim against African Barrick Gold.